Today's subject is jurisdiction. Jurisdiction is one of those fancy words. What does it mean? Well, a simple way of putting it would be it means power. It means power. There we go. It means power. And in terms of the court, and today we're going to talk about jurisdictions of courts as opposed to, say, jurisdictions of maybe the sheriff's department or administrative agency. We're going to talk about jurisdiction of the court, whether the court has the power to hear a particular case. All right. So jurisdiction is super important because if the court does not have jurisdiction, it doesn't have the power to hear the case. And therefore, anything that the court does is pretty much meaningless, right? So it's got to have jurisdiction. It's got to have the power over that case to be able to hear it, to be able to adjudicate it, which is super important. Why is this important to you? We're going to get into the details because there's a ton of stuff in here. There's constitutional principles, there's statutory principles, there's common law principles, there's a lot involved. But why should you care? Well, number one, as a paralegal, it's important to know what's going on. And if you're working on a case, working a case up for the lawyer you're working for, meeting with clients, it's important to know which court you're going to be before because they're going to be different. You know, last time we talked about state court versus federal court, and there's a lot of differences between them. This time we're going to talk about which maybe is the appropriate court to be before, which court has the power. And sometimes there's a choice, and sometimes it can be both. You can have one or the other. It's a choice. So it's important to know because you got to know which court you're going to be before. And the other thing that's important to know is if you're a paralegal, oftentimes you'll be asked to work up a case and to draft pleadings. And pleadings are the documents that are filed with the court. The first one you would file generally would be the complaint. The complaint is filed with the court to start the lawsuit. So that's, if you haven't had legal research in writing yet, you will get an opportunity to draft a complaint and see what those look like. Something that's super important to put in the complaint is jurisdiction. You have to plead the jurisdiction. You have to tell the court why this court that you're before has jurisdiction for the case. And I'm going to get to in a moment, there's actually two types of very important jurisdiction. And you have to talk about both of those. And it's a little bit detailed how it may differ in pleading in state court versus federal court. In state court, you're pleading things such as ultimate facts. In practicality, it's not going to make that much of a difference. But you're going to need to tell the court why it has the jurisdiction over this subject matter, which is the first type of jurisdiction, subject matter. And the second type of jurisdiction is personal jurisdiction. In other words, do you have, court, the power over these parties that are before you, or if they can be before that court? Both are important. The court needs to have both. They're treated differently, though, and there's different ways to look at it. I'm going to address first the subject matter jurisdiction, and then we'll get into personal jurisdiction. So let's talk about what is subject matter jurisdiction. Well, just like it says, it's well named. Does the court have the power to hear the type of case that's the subject matter of the dispute? So you've got some parties that have some sort of dispute. Maybe it's a tort case, a breach contract case. Maybe it's there's all kinds of cases that are out there. Maybe it's an antitrust case. There's all kinds of cases it could be. And we're going to have to see, does the court have the power to hear that particular type of case? And then you're going to ask yourself, is it exclusive? Exclusive jurisdiction would be something that can only be heard by that particular court. Or it may be concurrent. You may have a choice between state or federal court, and then in which case, and I think I mentioned this last time when we talked about the differences of the courts, the plaintiff is going to choose first. If it's concurrent, if there's a choice, the plaintiff is going to choose first, and they're going to file, let's say, in state court. If there is a proper basis for the court to be in, for the case to be in federal court, then the defendant has the opportunity, right in the beginning of the case, has one opportunity to what's called remove the case to federal court. Remove it to federal court. And you'll hear that called a removal action or removal. And what they're talking about there, if you hear of a removal, that means you're taking the case from state court and now placing it to federal court. Okay, so that's what that is. All right, so as I mentioned, we talk about the federal courts first. So if you're going to federal district court, which is the lowest level trial court, it's the trial court, the workhorse courts, the district courts. What type of cases does that court hear? Well, it's going to hear cases involving the United States Constitution. So if there's some constitutional, U.S. Constitution, not the state constitution, the U.S. Constitution, if there's something with that, they can hear it. If there's something dealing with federal law, say a violation of federal law, maybe it's a criminal case, a federal criminal case, that's going to be brought in federal court. If there is maybe a controversy or dispute between states, and we mentioned this last time, where, Texas sued Pennsylvania, the state of Texas sued the state of Pennsylvania. That was brought in the United States Supreme Court, because the Supreme Court of the United States has the original jurisdiction for those type cases. So that would be a federal court jurisdiction, and that's exclusive there. Maybe bankruptcy court. Well, bankruptcy is exclusively a federal jurisdiction. You're going to file in federal bankruptcy court if you have a bankruptcy case. And it doesn't matter, and it can't be, the one thing I was going to say is it can't be waived. It has to be, that's the only choice you have is federal bankruptcy court is where that case is going to be heard. Some other examples are Admiralty and Maritime. You hear those phrases thrown around a lot, Admiralty Law, Maritime Law, basically dealing with the sea, the ocean, disputes like that deal with ships. Something happens on a vessel. It could also be on the rivers, navigable waters. These are Admiralty and Maritime cases. You may ask, what's the difference between Admiralty and Maritime? Well, there used to be somewhat of a difference, but for all practical purposes anymore, there's really not. They're just used interchangeably. Maybe in depth there might be some slight difference, but generally we're talking about they're the same thing. It's just the same phrase used for both, the same name for both things, or one thing with two names. Those are going to be heard in federal court. Those are going to be heard in the federal district court. Now, here's one that we're going to talk about that's that there's concurrent jurisdiction. In other words, this is a case that can be heard in state court or federal court, and that's called diversity jurisdiction. And I touched on this a little bit last time. Diversity jurisdiction requires two things. It requires a dispute that's worth more than or exceeds $75,000. So this is not for a small case. This is for a large case, some kind of dispute, contract dispute perhaps. Maybe it's a tort. If you don't know what a tort is, it's like a personal injury case, a car accident, something like that. Defamation, those are all torts. And there's more than $75,000 at issue. In other words, that doesn't mean necessarily that the plaintiff is going to get $75,000, and it's got to be more than $75,000. It just means that we're fighting over it. So the plaintiff may say, you owe me $1 million, and the defendant says, I don't owe you anything. Well, they are fighting over more than $75,000. So check, that box is checked. You do exceed $75,000 at issue. There's a second part, and again, we're in diversity jurisdiction. You need both of these. The second part is the plaintiffs, whoever's bringing the suit, the people who are filing the lawsuit, have to be from a different state than all of the defendants. So if the plaintiffs are, say, in Florida and the defendants live in Georgia, no problem. You got diversity of citizenship there. But let's say you're suing two defendants and the plaintiffs live in Florida and one of the defendants lives in Georgia, but the other defendant lives in Florida. You don't have what's called complete diversity there. You don't have complete diversity. Therefore, you can't have diversity of citizenship case. So that federal court would not have jurisdiction in that case. Does that mean that the plaintiff's out of luck? They don't have a case? They can't sue anywhere? Of course not. They can then bring that same suit in the state of Florida, in the state courts. They were in the state of Florida. They were filing in the federal district court. They can then just go to a circuit court in the state of Florida and file the case there. So far, so good. I'm kind of going fast with a lot of this, and I may, from time to time go out on off to the side. And if you have questions, just type them into the chat box there, and I can see them. So feel free to do that. So diversity of citizenship case, that's one of those that maybe you might see a removal case in that case. Maybe that plaintiff originally filed in the state of Florida, in the state court, in the circuit court for, maybe Volusia County. But the plaintiff lives in Florida and the defendant lives out of state, maybe Washington State. And it's more than $75,000 at issue. That defendant could then remove that case to the federal district court. They'd remove it to maybe the federal district court, probably in Jacksonville, and the case would be heard then there. Now, sometimes the case might get sent back down, back to the circuit court if there's some, maybe if it's in bad faith that it was removed or something like that, or maybe there's something that destroys the diversity. Let's say another defendant is added, and another defendant might be from the state of Florida. Then you don't have the complete diversity anymore. There's also something called supplemental jurisdiction that the federal court has, and that's saying that. And again, if you haven't had legal research and writing, you may not be familiar with this. But when you're bringing a case, you can bring multiple counts, multiple causes of action in one case. So maybe you're pleading a breach of contract. Maybe you're pleading some sort of statutory relief. Maybe you're pleading also negligence. You're right down the line with several different things. Each of those is like a separate lawsuit within the main lawsuit. Well, let's say the main part of the lawsuit has something that has federal jurisdiction. Maybe it's a dispute over a federal law. But one of the other counts for relief may be just ordinary contract action. The federal courts can still hear that case under supplemental jurisdiction. They could just hear it all together because it's all part of the same transaction. Now, if that breach of contract had nothing to do with the main federal lawsuit, then they would split that one off. But let's say it's all part of the same, and this is where lawyers fight about that. Is it part of the same action or not? The federal court can hear all of that at that time. So far we've got federal court subject matter jurisdiction. And I'm going to repeat again because this is important. I wouldn't say it. I don't like repeating myself if it's not that important. Subject matter jurisdiction cannot be waived by the parties. They cannot waive it. What does that mean? That means by agreement or by action, the parties cannot confer jurisdiction on a court that doesn't have it. So let's say the parties are having a contract dispute, and maybe it's more than $75,000, but both parties live in the state of Florida. So there's no diversity of citizenship. But the lawyers could get together and say, hey, let's have this case heard in federal court. No, can't happen because that federal court independently will look at and say, hey, do I have jurisdiction to hear this case? And it will by itself throw the case out. It'll say there's no jurisdiction here, and it's going to throw the case out. So the parties can't agree to confer any kind of subject matter jurisdiction to a court. So it's either there or it's not. And that same thing applies also in state court jurisdictions. So that's the state courts. That's the federal courts. Let's talk about the state courts since I brought that up. And again, we talked about this a little bit last time because jurisdiction has a lot to do with which court you're in. There are new jurisdictional limits in the state courts. State courts have broader jurisdiction. Federal court, you really have to have some very specific things because the federal courts are set up by the Constitution. The state courts are kind of your workhorse courts, and they pretty much hear everything else. So there were some new jurisdictional limits set in 2020 last year, and they just kind of bumped up the jurisdictional limits for the different courts. The lowest court in Florida, we talked about last time, is small claims court. Small claims courts will hear cases that there's a dispute up to $8,000. So $8,000 is that number that if there's a dispute of that amount, they'll hear that. They'll hear that case. So $8,000 and below. If you have more than $8,000, up to $30,000, the next court is going to be the county court. You're going to go to the county court and have your case heard there. Now that $30,000 limit, that's excuse me, that's going to change. I think in 2023, that's going to be changing up to, I believe, $50,000. It's going to go up to $50,000. So you'll be able to bring cases up to $50,000 in county court. But right now, today, it's at $30,000. Anything above $30,000, then you're going to go to the circuit court. You're going to go to the circuit court, and that'll hear any cases up to unlimited amount of money, right? Also, for the criminal cases, the county courts will hear your misdemeanor cases. So if it's a misdemeanor criminal case, that's going to be heard in the county court. Felonies, however, are going to be heard in the circuit court. So if you have your chart that I had last time, and if you want one of those charts, I'll send them to you. You can email me at robert_capko@datonastate.edu and ask me for one of those, and I'll send it to you. And that's going to just show you the different levels of the courts, and it's clickable. You can click on the link, and it'll take you to that court's website, so you can look a little bit more about that court and the jurisdictional limits. So state courts are going to hear your divorce cases, your probate cases, things like that are all going to be in state court. Your replevin cases, there'll be receiverships, all kinds of cases that are in state court. But again, you cannot confer upon the court any kind of jurisdiction for subject matter by agreement. So if the parties say, hey, it'd be a lot easier to hear that bankruptcy court case down at the county court, it can't. Bankruptcy is exclusively a federal jurisdiction, right? So that case has to be brought in the federal bankruptcy court. So that's the important thing about subject matter jurisdiction, is it cannot be waived. It cannot be conveyed later. It has to be in place for the whole time of the case. And if for some reason something happens that removes that subject matter jurisdiction from that dispute, then that court can no longer hear that case. So it has to have jurisdiction throughout the court case. So if something happens that maybe there's no longer, with the state courts, if you brought it to removed it to a federal court, and all of a sudden you don't have complete diversity, you can't hear it then in the federal court anymore. So it's really important on the front end to ask yourself, what court has the right subject matter jurisdiction? So, and as I mentioned to you, there's two types of jurisdiction. Subject matter is one whole area, and that's what we've been talking about. Does the court have the power to hear this kind of case? The second type of jurisdiction, and the courts have to have both. And when you plead the case in your complaint, you got to list both. And what facts back that up? Pardon me. The second type of jurisdiction that the court must have is called personal jurisdiction. Personal jurisdiction. In other words, jurisdiction or power over the parties. Does the court have the power over all the parties to the suit? And if for some reason the court doesn't have power over a particular party, then it cannot adjudicate anything with regard to that party. It can adjudicate stuff regarding the parties that it does have jurisdiction, but not any parties that don't. And you may ask yourself, Well, doesn't the court just have power over everybody? No, not necessarily. Let's say you're here in you want to go to the circuit court here in DeLand, and you want to sue somebody from California over, I don't know, a car accident that occurred in California. Well, and the accident occurred in California. The person lives in California. They never appeared here in Florida for any reason. It wouldn't be fair. It wouldn't be fair to sue them in the state of Florida, right? You would have to go to California to sue them. And that's kind of the idea of personal jurisdiction. So the first thing we're going to look at is who does the state courts, and for this, I'm going to mainly look at the state court ones because you're going to have a lot broader personal jurisdiction over with federal court, but it's kind of the same ideas. But let's talk about the Florida, what's called the long arm statute. For the long arm of the law, well, the Florida's got a long arm statute, and that will tell you exactly who the state courts can exert power over for purposes of personal jurisdiction. So I'll give you the citation just so you can take a look at it. It's Florida statute 48.193. So section 48.193. So you'll be able to look at that yourself and see the Florida long arm statute. And most states have something similar. And you're going to look here, and that's your starting spot to see, can the state exert in state court jurisdiction over a party that's not in the state? Now, if you live in the state, the court's going to be able to exert jurisdiction over you because you're residents here, right? But we're thinking about people who are outside of that state. Well, let's look at that, because just looking at the statute is not enough. Of course, anything in the law, looking at one thing's not enough, right? It's a two-step process. You look first to the long arm statute to see, well, if you look at the statute, does the defendant, and we're talking about the defendant here, fall into one of these categories? The second part is whether or not the defendant, whether it's going to be within due process, which is the constitutional application, right? A constitutional concept, whether under due process, the court has jurisdiction over that person. So we can look briefly at the long arm statute just to get an idea of what types of things that would subject somebody to jurisdiction of the state Florida courts. One thing would be engaging business in Florida. So if you have substantial business in Florida, you're selling to Florida, maybe you're in California, but you're shipping stuff all the time to Florida, you have customers in Florida, you're making money from Florida. Well, then you have subjected yourself to the jurisdiction of the state of Florida, and under the long arm statute, that would bring you within that, right? The second thing would be committing a tort in the state of Florida. So like committing a personal injury, something like that. So you come to Florida, you're going to Disney World, and you're driving down I-4, and all of a sudden you see, oh, the exit's all the way over there, and you cut across 5 lanes of traffic. I know that never happens. Tourists never do that. But if you did, and you crash into somebody, and it's your fault, you can expect to be sued in the state of Florida, even if you're a resident of somewhere else, right? So because you committed a tort, in this case, negligence, within our state. Let's say you own real estate here, maybe a vacation home, rental properties, a timeshare. I don't know. You have some real estate here. Now that would subject you to state of Florida long arm statute, personal jurisdiction. Maybe you contract for insurance here. Maybe you're an insurance company and you're based in Omaha, but you're selling insurance policies to the state of Florida, to people who live in the state of Florida. The long arm statute would get you with that. Breach of contract. If you commit a breach of contract here in the state of Florida, you had to maybe ship some goods here and you failed to do so, or they were, substantial, they were subpar goods or something that breached contract in the state of Florida, you had to pay money in the state of Florida. Long arm statute is going to say that you are subject to personal jurisdiction in the state of Florida. And then here's an interesting one here. If you conceive a child in the state of Florida, then for purposes of paternity proceedings, long arm statute says we got you. We can force you to come to the state of Florida to defend yourself, right? So, and there's some other things in there, but those are some of the biggies that I jotted down. But take a look at that statute, and if you're drafting a complaint for the lawyer that you're working for, look at the statute. Always have that in front of you. Which one are we falling under? And you would actually probably cite that actual section and subsection. That's always a good thing to do. There'll be no question about it then, because then you're pointing the court exactly to where the jurisdiction lies. But as I said, that's not the end of the story, right? It's one thing to fall under the state of Florida long arm statute, but that's not the end of the analysis. There's a second analysis that the court undertakes independently. Now, you want to kind of plead to it. You want to at least have the information there, so when the court looks at this, or if it's challenged, it's got the information that it needs. But I think I already mentioned it to you. It's regarding the Constitution, and that's a due process, right? Is it due process is the thing we're going to look at. So what let me get the exact language here for you. So they're going to look at whether it's let me get the right language here. Of course, the due process, the independent analysis is going to look at, does the defendant have sufficient minimum contacts? And I knew that part because that's the key phraseology there. Minimum contacts to not get this offend traditional notions of fair play and substantial justice. So, does the defendant have sufficient minimum contacts to not offend traditional notions of fair play and substantial justice? That's actually from a Supreme Court opinion. There's a Florida Supreme Court opinion called Georgia Insurers Insolvency Pool versus, I think, Brown. And that's quoting a United States Supreme Court case that everyone who goes to law school has heard of, and it's International Shoe versus Washington. And this falls upon the idea of foreseeability. Is it foreseeable when you're doing whatever you're doing as the defendant that you could be pulled into the state of Florida to defend yourself? So it comes down to the foreseeability. And that's what the court's going to be looking at. Because if it's not foreseeable, if it's not within due process, so far outside of what's foreseeable, so far outside of the traditional notions of fair play and substantial justice, then the court would say you don't have sufficient minimum contacts, and therefore you cannot be sued in the state of Florida. They cannot be sued in the state of Florida. Is that the end of the road for the plaintiff? No, you can just go to the defendant's home state and sue them there, right? There's nothing to stop you from doing that. And you're going to say, well, wait a minute. If you're the plaintiff and you've never been to that state, how is that state court going to have jurisdiction over you? That's because personal jurisdiction, unlike subject matter jurisdiction, is waivable. The parties can waive personal jurisdiction. They can do it by agreement, or they can do it by action. So if a party, for example, let's say we're filing the lawsuit here in the state of Florida against a defendant from California, and you make your allegations that, whatever you think that long arm statute would say and whatever the minimum contacts are. But let's say you're wrong about them for whatever reason. You sue that defendant hires a lawyer, comes to the state of Florida, and files an answer to that lawsuit. Guess what? They just subjected themselves to the court's jurisdiction. They have waived their argument for personal jurisdiction because they now have said, court, we'll let you hear this case. We're okay with it. They didn't object on the front end. So that's the important thing from a defendant's point of view. If the defendant believes that they have a legitimate objection to the claim that there's personal jurisdiction, they have to raise that on the front end. They have to raise it right away with a motion to dismiss. And they can do it through what's called you could say, well, by them filing the motion to dismiss, aren't they subjecting themselves to the court's jurisdiction? There's a little wink and nod. The court's gonna let them file a motion to dismiss, and the court can hear that case without the party waiving their objection to personal jurisdiction. It just wouldn't work any other way. So the court would hear that motion to dismiss and rule either, yeah, there's no personal jurisdiction, and then dismiss the case, at least as to that defendant, or dismiss that defendant from the case. Or the court's going to say, yes, long arm statute satisfied, and the due process is satisfied. So you, defendant, now have to defend yourself in court here in the state of Florida. So the defendant would then have to file their answer at that point. So that's gives you an idea of all of that. Let me ask you this. Does anyone have any questions? I know I'm covering a lot of material here, and when I started putting this together, I realized, wow, there's a lot. So I'm kind of talking fast, which, any questions at all? How does long arm statute work for companies? Excellent question. That's an excellent question, because I meant to mention that also with regard to subject matter jurisdiction as well. The question when it comes to companies, and we're talking about companies, we're talking about entities, right? Like a corporation, limited liability company, limited partnership, something like that. Where's that company from? Where does that company reside? That's the key word, right? Where does it reside? That's also important if we back up and talk about subject matter jurisdiction for the federal courts, for that diversity jurisdiction. Remember, I said that there has to be complete diversity. The plaintiff and all the defendants have to be from different states, right? The defendants can be from the same state of themselves, but none of the defendants can be in the same state as, or cannot reside in the same state as the plaintiff. The question is where's the company reside, right? Is it, let's say you're suing Walmart. Well, if you're suing Walmart, Walmart's everywhere, right? Or let's say you're suing Home Depot. Home Depot's everywhere, right? They're in Canada, they're in Mexico, they're everywhere, they're in Guam. Does that mean they reside everywhere? No. You look to where that company is incorporated, and you might be looking at also where their principal place of business is. So it might be looked at a couple different ways. You could argue where the residency is, but you're generally going to be looking at where they're incorporated. Are companies always incorporated where their principal place of business is? No. There's a lot of companies that you would recognize the names, and they're incorporated in the state of Delaware. And that's because Delaware has some very favorable corporate law. And so they've set it up where they pretty much encourage people to incorporate in the state of Delaware because of that. So folks are going to, so that would be where that company is residing. And the same thing for the long arm statute. This company, where you're going to look at where it's incorporated, right? So that's where it resides. However, again, because if we're talking about the long arm statute, if the company is doing business in Florida, it doesn't matter where they reside. It matters where they're doing business for purposes of the long arm statute. If they're doing substantial business in Florida, then yeah, they're going to be found to be subject to Florida jurisdiction. And that's not a surprise to the companies. These companies have sophisticated lawyers, legal departments. They already know that. That's already factored into the risk. They already got lawyers on standby in each of the states. Now, there was an interesting case back in 2010 dealing with a blogger. And they were, I think, in the state of Washington. And I believe they were sued in the state of Florida for, I believe it may have been defamation. I'd have to look at the facts again. They were sued I think it was for defamation in the state of Florida. And the blogger basically said, hey, I didn't target anybody in Florida. I just went ahead and was blogging about stuff from my home in Washington State. Well, this case was in federal court, and they went to, there was a question certified to the Florida Supreme Court on whether or not that defendant, whether the long arm statute was satisfied with regard to the defamatory material that was apparently the Florida resident was defamed, and whether that was published in Florida. And according to the state of Florida, to the Supreme Court, they said, oh, yeah, that satisfies the Florida long arm statute. So there's a potential there that somebody writes a blog somewhere, and they could anywhere, the internet's everywhere, right? You could subject yourself to being sued in another state based upon that. So there's always these risks that people undertake when they engage in stuff like this. That was an excellent question, though. Any other questions? So let's look at the overview, and then we'll wrap it up, because I think my little countdown's telling me I'm almost out of time here on the Teams meeting. Jurisdiction, power of the court over the case. Two main types: subject matter, personal. Subject matter cannot be waived. Subject matter either exists or it doesn't. You look at the type of matter that's being sued about, or the type of statute that you're disputing, whatever it is, whatever the lawsuit's about, the court has to have the power to hear that. Second thing is going to be that personal jurisdiction. Personal jurisdiction can be waived. The party can agree to be heard in that state. Personal jurisdiction, long arm statute is the beginning of the process. Do they fulfill any of that, the little steps in the long arm statute? If they've done any of those things in a long arm statute, that's part one. Part two, substantial justice. Did they engage in minimum contacts? That's the word that you're going to hear. Just say minimum contacts. Everybody knows what you're talking about then. If they had minimum contacts with the state of Florida, boom, personal jurisdiction. So you've got to have both. One of them can be waived, one cannot. Another question. Kind of curious about international. Yeah, international, there disputes with foreign entities can be brought in federal court. That's one of the federal court jurisdictions, and you might be able to subject them also to state court jurisdiction if they're doing business in the state of Florida. So as long as they're doing business in the state of Florida, you might be able to reach them. Good. I'm glad you found it useful. Excellent. With foreign defendants, maybe you may win the case. Maybe good luck